let's talk about reducing your risk as a business owner. So, as many people know, I do litigation. I'm also going to be taking my makeup and stuff off. I do a lot of litigation, small business litigation, and it's always surprising to me when business owners are surprised that they have been sued. I feel like it's sort of a rite of passage that, you know, if you're successful, you're going to be sued. Everybody who has a business, and so, at some point, again, if you're successful, you're probably going to get sued. And so everybody should be ready for it. I have had, oh, sorry, let me put this on. I've had two different clients this week who told me they were sole proprietors. Sole proprietors. That means that they have been operating a business, and these are businesses with employees. Some of them are in several states. They have assets, and I would say that both of them have six-figure revenues. Both older people, and I do think that's relevant, right? Because they're not like on small business TikTok, learning about everything that could go wrong. Nevertheless, surprising to me that they didn't form an entity, and they have businesses with storefronts and real estate and all these things. Um, and it never occurred to them that it would be a problem until now. Now it's a problem. And so with both of them, I said, okay, the point of forming a business entity, the point of incorporating or being an LLC is not just to save taxes. I see so many of those videos that pop up in my feed, which I think are great, that they're like, oh, you need to be an LLC. You need to be an LLC, and if you're an LLC, being taxed as an S corp, you give 95% to the trust, you get 5% to a family trust, and so you pay no taxes and all that stuff. That's great. And I think everybody should listen to that. I do all of those things, the Augusta rule and all that stuff. I think everybody should do that. People are shocked when they look when I tell them how much I pay in taxes legally, legitimately. When they see just my lifestyle and that kind of thing, because I follow those rules. That's what rich people do. I do that too. So the purpose, though, of those entities is not to save taxes. That is not the point. The point is not to save taxes. It is not. The point is to reduce your risk. Reduce your risk of losing your entire business. So yeah, you can save on taxes, save $20,000, $30,000, $40,000 in taxes. But if you don't reduce your risk by actually using those entities the way they're intended to, then it doesn't matter. You won't have a business. You definitely won't be paying taxes because your business is gone. So I'm super surprised when folks are just, just kind of sitting out there, not doing anything, not, minimizing their risk. So with these two people, both sole proprietors, both have been sued. And so I say, well, are you judgment proof? They're both like, what? What's judgment proof? Being judgment proof means that you don't have to get all hot and bothered about whether somebody sues you, because it doesn't matter. Your assets are set up in such a way that it doesn't really matter if someone sues you. They'll get a paper judgment. And a paper judgment means, yeah, the court ruled against me. I now owe this money. But if you don't have any money that is available for the court to attach to, it doesn't matter. It's not going to affect your credit. It's not going to stop you from getting investments or business loans or any of that kind of stuff. So every business owner should be judgment proof, period. There's no excuse. It doesn't make sense that you have $5 million in revenue, or even $1 million in revenue, or even $10 in revenue without being judgment proof, because being judgment proof takes no more effort than the effort that it takes for you to lower your tax, your risk of paying tax, or your tax burden. No more effort than your tax burden. None. You just have to know what to do. You have to know where to put your assets. Being a sole proprietor does not make sense, ever. There's no situation in which that makes sense. Because as a sole proprietor, your personal assets are at risk, period. They're at risk. If someone sues you, they're suing you personally. There's no difference between a sole proprietorship and just the person. It's the same. So it just doesn't make any sense to do. So in both situations, what are we doing to fix it? It's too late on those litigations. It's too late. If we start moving stuff around, it's just going to be seen as fraud. Are we going to do it? We're going to do it after the litigation. We're going to plan for it now. We're going to do all that we can to try to mitigate their risk, and you know, and that they may have to file bankruptcy, to be honest, because of the sole proprietorship. But in general, there's so many ways. If you are a real estate investor, for example, people go on property, even if they're trespassing in most states, if they get hurt on the property, if they step on a nail on your property, you're liable. Like they could sue you for that. And they will sue you for that. Like it's gonna happen. They're actually gonna sue you. It happens all the time. You should make sure that there is not enough revenue in that company to make a lawyer want to file that lawsuit. You want a lawyer to look and say, oh my goodness, not only is there a company there to manage, there's another company there to own the assets. There may be another foundation there, for example, that those entities are giving money to. Now, the issue that I have when I see folks recommending these structures online is that they miss a big step. It's the contracting that is the issue. Anyone can go out and go to the Secretary of State and file a one-page articles of organization for an LLC and then put down as the owner another LLC or a trust. Anyone can draft a trust document. The issue is when we look at most of the documents that are done by some inexperienced CPAs, or people look at the videos from the CPAs and they try to do it themselves, they're just forming the entities and they make the entities own each other. That's not how you reduce your risk. It's also, quite frankly, also not how you reduce your tax burden. Because if you get audited and your contracts aren't right, that's where the issue is. The contracts. If you have a management company that's managing the assets that are held in another company, you have to have a management agreement. You can't just have the different companies with a holding company. You can't have a holding company, management company, an asset company, and then some other company. That makes sense, right? Because each company, because of the way the money is moving around, and then the profits are essentially going to be swept up to the holding company. The holding company doesn't do business, right? So you can't sue the holding company because the holding company can't do anything wrong because all they do is hold money. It's a great tax shelter. The management company is only going to get paid enough to cover the salaries of the managers, and that's going to be paid by the entity that's actually doing business. But the entity that's doing business may be borrowing or leasing out the managers. They may be borrowing from the asset company. They may only buy the vehicle immediately before they sell it in the same kind of transaction. So they're all bankrupts. But the problem is, do you have the agreements in place? Is there a management agreement between the management company and the operating company? Do your agreements say how much money is supposed to be swept up? You can't sweep the money up when something happens. It has to be systemic. You have to have a policy in your operating agreement that says, hey, any profits that we earn are going to be stored in the holding company. That has to be written down. If you're going to claim that those managers work for the management company and they don't work for the operating company, there has to be contracts in place to set that up. Otherwise, what you've done is not going to work. If you get audited, you're going to be paying. If you get sued, it's not going to work. In fact, it may be fraud if you don't do it right. And you also have to make sure that you actually do it. Whatever your operating agreement says that you do on a daily basis, that's what you have to do. If it says you meet every Thursday at 5 o'clock at Shenanigans, that's what you have to do. If you dip into the money of a child company and then you use it for another company, then those companies could be seen as the same company. And this could be seen as a sham. And then there's no risk, and then your personal assets are up for grabs. So be super careful and make sure you're judgment proof. So after you leave your CPA's office and they set up all these entities, then go right to an attorney's office and ask them to make sure that all the agreements are in place, to make sure that there is no piercing of the corporate veil. If you don't know what that is, look it up. Make sure that there's no fraud, and make sure that you have every agreement between every entity in place to make sure that what you're trying to do, which is to reduce risk and to reduce your tax burden, to make sure those contracts are in place to do just that, because simply forming the organizations won't do it. Again, my name is Ahaji. I'm a small business attorney. I'm licensed in Missouri, Texas, North Carolina, and for the U.S. Patent and Trademark Office. I love to represent startups. I love M&A. I love IP law, and I am a litigator. But I'm not your litigator, and I'm not your lawyer. And this is not legal advice. This is practical advice, literally just based on what I did today and the conversations I had today. So please go out and get yourself a lawyer so that you can stay in business while you are saving on taxes. I hope this helps. Bye bye.